oh, you know what, 2-3 weeks ago, maybe a month ago. And we did not have the guidance. We now have the guidance. Shockingly, the department has said, oh yeah, and we're going to be doing regulations, but those regulations are probably 6 months off. So we know what we know. We're going to have to make some educated guesses here because we will not have all the rules available prior to the 1/1/2021 use date. So we'll go through it. You will have questions, I can guarantee it. We will make educated guesses in that regard, and we see where we turn out. You may have to make adjustments in early 2021 to your written policy. You must have a written policy. It must go out before January 1, 2021. I'd encourage you to get it out sooner rather than later. We're working with many employers right now to get their policies finalized. There's a lot of issues here. The handouts should have been emailed to you already. If not, if you don't have them, check your email and then let me know or let the chamber know if you didn't get them. We will do questions. You're free to put it in, I think the chat box. Yeah, there's a chat. I will answer the questions. I'll try to answer them as I go along. If not, I'll take them all at the end in that regard. So with that, we'll jump right into it. I put my contact information here. I'm happy to answer general follow-up questions. I did a webinar the other day. I got a 2.5-page email of questions about it. Too much. Again, general questions, happy to answer in that regard. I am on Twitter and LinkedIn. You're free to follow me on Twitter. It's automatic. I don't have to approve you. LinkedIn, I will let you into the network. I literally post information on labor and employment topics every day in other areas of the law. And I put my presentations up there in case you want to join another webinar on this. I think there will be another webinar on the New York State paid sick leave, maybe 2 in 2021. This is actually turning into a big deal. Many employers are shocked at some of these rules, but these are rules we have to follow. Some of the rules, like some of the carryover rules, make no sense. I get it, but we will. Those are the rules, and that's what we have to deal with. Our agenda today, and let me just take a step back. Those of you that heard the first version of this presentation, some of the slides are the same. What I did is I incorporated the guidance into the overall materials I prepared the first time, changed the agenda around a little bit. I'm probably going to tweak it some more as we go through. Some of the slides could be in one section or the other section. It's so there'll be some overlap on these. It's nothing major. It's just where I'm telling you where I put it. So we'll go over some general information on the New York State Paid Sick and Safe Leave Act. We'll talk about who a covered employee and a covered employer are. They've given us some more guidance. Nothing earth-shattering is what I thought to begin with. We'll talk about the leave requirements, the various buckets that are available. Typically, it's going to depend on the size, i.e. how many employees you have. Now, the problem is the government hasn't told us how to count the employees. So that's going to be the subject of their regulations. We will make some educated guesses. I will tell you what I think. I think my conservative approach is probably the way to go until we get some guidance otherwise. We'll talk about the eligibility rules. Some of you have policies, hey, during the first 90 days of employment, you can't take any time. Well, that's no longer true under the Paid Sick Leave Act, and we'll have to modify some of those rules. We'll talk about the benefit requirements and funding options. We knew about accrual, we knew about front loading. The accrual method works easy for part-timers. What they gave us is how to front load for a part-timer and how to, quote, accrue for individuals that don't necessarily track their time, like an exempt person. And it turns out you're going to have to track their time, how many hours they're actually working. We'll talk about the employee's use of sick time. There's some guidance here that is helpful. So for instance, if an individual is taking domestic violence leave, or what they refer to as safe leave, does that mean there was someone arrested? Does that mean the employee had to go to the police to press charges? The answer is no in that regard. Lots of questions have popped up about rate of pay and how I pay my employees. Those questions will continue. I had a lot of great questions in the webinar I did yesterday on prevailing wage, which we really have to work through in that regard. What the rate is we have to pay them if someone gets sick on a prevailing wage job. We're going to talk about notice and related issues. Let me be frank, they don't have to give but 1 minute's notice, 1 second notice to use paid sick leave, and there's nothing you can do about it. Let me just be frank. What they did not give us was any rules indicating what we can or cannot ask for as far as supporting documentation to support the leave request. So we're left with a very general rule that is in the statute. I will tell you my thoughts. It will be the subject of the regulations. Are my thoughts correct or not? Yeah, I guess we got to wait for the regulations. We'll talk about the non-discrimination rule in the statute. We'll talk about your existing PTO plans. You can use them if you wish. I am telling you, my advice is to pull out the sick leave and to do that separate from your PTO, but you are free to keep it in that regard. We will go through what those rules are in that regard. We'll talk about the impact of collective bargaining agreements, the job restoration rule. They must be restored to their same position. Employee usage rule, basically if the employee asks, how much sick leave have I accrued? How much have I used? What do I got left? You must respond within 3 business days in writing. We'll talk about the impact of other laws. I've read many commentaries that now turn out to be wrong. COVID-19 sick leave under New York law and New York State paid sick leave are independent of each other. They don't run together. There was some guidance released explaining the interaction between paid sick leave and paid family leave, which we will go over. And then there was some guidance released that said paid sick leave is above any other federal or state leave requirement. So I think you could make it work, run concurrently with FEMLA. I think you just got to review the FEMLA regs in that regard. Lastly, our last 2 points, impact of other laws. We will talk briefly about the New York City law, the Westchester County law. They remain in effect as well. And then record retention requirement, no change there from the last presentation. So let's start out with general information. Again, the law was placed in Article 6 of the labor law, which is payment of wages. That law already had in effect a definition of who an employee is and definition of who an employer is in that regard. If you're choosing the accrual method, the accruals had to begin on September 30th, 2020. If you have not polished or published your policy yet, when you do, if you're using the accrual method, you will state that the accruals are retroactive to September 30th, 2020 in that regard. The use rules go into effect on January 1, 2021. I would not try to enact it ahead of time. I had a couple employers that want to do that. I think the answer is no. The time must be available effective January 1. So anytime you give them prior to that, you can't count against them for 2021 in that regard. So don't start the use rules until 1/1/2021. The guidance that I'm going to go through here today was issued on October 16th. They issued frequently asked questions. I've given you the link here. They also created a website. There's not a lot on it yet, but I've given you the link to it. I've reviewed it a couple times. I think they're going to slowly populate it with other information to help you answer questions. So you may have to check that, you know, maybe once a week going forward. As I mentioned, the Department of Labor will also be publishing regulations. It's probably going to be 6 months before they're final. They haven't even been proposed yet. Once we see the proposed regulations, we may do a webinar on those just so you sort of know what the department is thinking on these issues and to sort of give you a heads up. And then definitely we're going to do one once the regulations go final. It is mandatory, no exceptions. Everyone on this webinar must put in place a written paid sick and safe leave act policy. You must do it on or before January 1, 2021. I encourage you to do it sooner rather than later. Two things: I would post it and I would distribute it to all your employees and get a sign off in that regard. The policy, as you see here, must include any limitations on leave increments. Okay. I will explain that later on. It's not that you can deny the leave, but if Johnny wants to go to a doctor's appointment, you as the employer has the right to say, you must, if you take sick time, you must take it in a minimum of 4-hour increments. You can use less than that if you want, but you can't use more. If an employee needs to take a day and a half off for sick time, they are allowed to do so. If they need to take 3 days off, they are allowed to do so. There's someone who is not muted. If you could please just mute yourself, that would be great. I appreciate it. So we will talk about the policy throughout. You will see there's lots of things for you to consider. There's lots of business decisions you're going to have to make in this regard. The minimum increment of use is going to be one of them that you as the employer will have to decide on, and decide fairly quickly, because we are at T-minus 2 months. Covered employees and covered employers. The law adopts the existing definition of an employee. It means anyone working for you. Does not include independent contractors. There is no distinction between full-time, part-time, per diem, seasonal, temporary, and students. If there are any higher ed on, your student employees are in fact covered by this law. If you have a paid intern or a paid co-op student, they are covered by this law. If they're an employee, they are covered. Immigration status is irrelevant. If you cannot deny paid sick leave to someone that you discover is illegal and should not be working. That does raise another question. You know, can you continue to legally employ them, or are you committing a felony by doing so? And I'm happy to have that discussion with you on the side. But don't knowingly employ someone who is illegal. It is probably a federal felony level offense. Domestic workers are covered. Their guidance clarified that the New York State paid sick leave requirements are on top of any leave requirements that domestic workers are given in the state domestic workers Bill of Rights. An employer is all of you that are on this call, unless you're a governmental agency. Federal, state, and local employers and their employees are excluded from this law. They are not covered by it. However, employees of charter schools, private schools and not-for-profit corporations are in fact covered entities. Again, sort of saying the same thing in a different way. The guidance confirms the law covers all private sector employees, regardless of industry, occupation, part-time, full-time status, overtime exempt status, or seasonal status. It makes no difference. They also gave us a seasonal rule. Construction, we shut down in the winter, we start back in the spring. There's a gap in employment. Does the time roll into the spring when I bring the employees back? The answer is yes, it does. And I'll go through that guidance with you. Make no doubt about it, this is an unfunded employer mandate. You have to provide this to your employees. And what you have to provide will be contingent on how big you are, the number of employees, and in 2 cases, the net income of the employer in the prior tax year. Great question has popped up. If someone is working in another state but is paid by the New York employer, are they covered? They are only covered, Terry, for the time they are physically working in the state of New York. If they never physically work in the state of New York, they do not get any paid sick leave benefit under the law. I will come to that guidance in a minute and explain it to you. When you determine the employee count, you're going to use calendar year 2020. Every year you're going to have to redo the calculation to see if you fall into which bucket going forward. And I'll explain that in a second. So when I count my employees, I use a calendar year method. I use January 1 through December 31. I think until we see further guidance, I think it's as simple as how many employees did you have on your books that year? Terminated, inactive. They're not saying look at a particular payroll period. They're not saying on average. I think it's a number count. How many did you have on your books? What is your employer identification number? And let's count them up. I think that's the conservative approach until we see this guidance. Please remember, it is a yearly evaluation. So if I currently, in 2020, have 99 employees, I have to provide 40 hours of paid sick leave. In 2021, let's say my number jumps up to 110. That would mean in 2022, I have to provide 56 hours. So you're going to have to do this evaluation on a yearly basis. Another question that popped up on this, what I call teleworking, which we'll get to some slides on it, as a follow-up to the question that was just asked. What if a PA employee is working remotely in PA, but handling work in New York? Same answer. As long as the employee does not physically work in the state of New York. So this Zoom meeting will not count. They have to physically enter the state of New York. And when they physically enter the state of New York, you would accrue benefits for them based on the hours they work in the state of New York. Fun, huh? Yeah. It's really going to cut down on people traveling across state lines for the employer. What if the business has multiple locations within the state of New York with 4 or fewer employees at each location? Basically, do we have to count them all? The answer is yes, you do, as indicated here. The question that is left open by the guidance, if it's the same company, but I have employees in Pennsylvania, do I also count them? I think the conservative answer, until they tell us to the contrary, is yes, you do. They just don't get the benefit of the law unless they come in. But for purposes of determining how many employees you have, the guidance has not said you only count the New York employees. the statute does not say you only count the New York employees. They may clarify that and change that with the regulations, but until they do, I think that's how I'm going to interpret it, because it's grabbing the largest number in that regard. Some of the slides, like the one I just went through, was an example that I sort of summarized for you. I'm not going to read you the slides necessarily word by word. Some of them I will. There's additional information there if you want to take a look. Leave requirements, the buckets. Even though it's called the Paid Sick and Safe Leave Act, one of the 4 buckets that exist is unpaid leave of up to 40 hours. I'll explain up to in 1 second. So the first bucket, 4 or less employees and less than $1 million of net income in the prior tax year. You got to look at your tax return to figure that out. In that scenario, the employer must provide up to 40 hours of unpaid sick leave in the calendar year. Up to, what the devil does that mean, Mike? Don't I just give my employees 40 hours? No, you could front load all 40, or you could allow them to accrue. If they accrue, it is based on how much they work, and they may or may not, based on how much they work, get up to 40 hours. We're going to cover that a little bit more, both the accrual method and the front load method, when we get to the funding part, which is coming up. The second bucket is 4 or less employees, but your net income is greater than $1 million. The 40 hours of unpaid leave now becomes 40 hours of paid sick leave. If you have between 5 and 99 employees, please know the income is gone now. It is not part of the test. So if you have between 5 and 99 employees, you're obligated to provide 40 hours of paid sick leave. And if you have 100 or more, it jumps up to 56 hours. Mike, I'm a nice employer. I'm going to give more sick leave. Is that okay? Sure. It falls into a business decision, a business judgment. You are free to give away as much money as you want. You are free to have as many lucrative benefits as you want. Now, remember, if you do that and you are hit with hard financial times, you're going to cut back on benefits. We have seen employers faced with a unionization effort if you start cutting benefits. So just be cautious, keep that in the back of your mind. Also realize if you have separate vacation and personal time banks, you sort of may have to rework those given the amount of sick leave that an employee is being given. Okay, let's talk a little bit about eligibility rules. Is there a minimum period of time of employment before the employer is responsible for providing sick leave? No. On day 1, you either front load or the employee starts to accrue. If you front load, the employee can start using their leave on day 2. If you use the accrual method, the employee can start using sick leave as soon as they accrue enough to use. Is there a minimum period of employment before the employee can use their sick leave? And this is where if you have a policy that says the first 90 days of employment is the probationary period, you're going to have to revise that if it says you can't use any benefits during that period. Question has come up. We give 40 hours of PTO every year. Do we now have to give an additional 40 hours of sick time? Lisa, you do not, and I will cover that when I get to that provision. There are rules you're going to have to comply with and live by. So you're going to have to comply with the use rules, the accrual rules or front loading rules, if that's what you're doing, I can't tell, and the carryover. You're going to have to carry over unused time. And as long as you're willing to follow all those rules, that's going to be fine. But you may have some what I call HR issues going on there, and I will discuss those when we get to that in that regard. Does an employer have to provide sick leave to employees who telecommute outside the state of New York? I've already answered this. You only get the leave when you're physically, or you only accrue it when you're physically working in the state of New York. Okay, I did have another question pop up. Okay, so, sorry. Okay, for 80 hours a year, they would accrue 69.33 hours. They will earn 56 hours before October. Would they continue to accrue the rest of the year or only eligible for 56 hours? John, you can cut off the eligibility at 56 hours. I'm assuming you have 100 or more employees. You do not have to allow them to accrue more than the maximum that the law says, but put that in the policy. So, dear employee, we are only allowing you to accrue up to 56 hours in the calendar year. Put that in your policy, and you're going to be good to go in that regard. Next question. An employee is sick. Can the employer require the employee to telecommute or work from home instead of taking sick leave? No, it is the employee's option. They claim they are taking sick leave. They do not have to take you up on your offer. They can if they wish, but they do not have to. Okay, let's talk a little bit about benefit funding and funding requirements. I've already mentioned, and as you all know, two options: front load or accrual. That's it. All right. Front load. You front load all of the time on January 1. Some of you want to do it quarterly. Not acceptable. If you front load, the only acceptable method is on January 1, 2021, you fully fund. Front loading is the good reason to do front loading is it's easy. I don't have to track throughout the year unless it's a part-timer. And if it is, the bad news is I front load on January 1. I give you 56 hours of paid sick leave. I know I'm leaving on February 15th and giving notice. I'm going to be sick a lot in January. I use all 56 hours in January. I resign on February 15th. Can I recoup any of the time? No, you cannot. Once you front load, you can't take it away. Let that sink in. What if someone, an unanswered question is, what if an employee joins us on December 15th, 2021? Do I front load the whole amount for 2021? I don't think so. I think you front load just enough to cover their time that they're going to work in 2021. I think you prorate it. There's no guidance. There's no law on that, but I think it just makes sense. Otherwise, it's a windfall to the employee. The other method is the accrual method. As I've indicated, they work, they earn sick leave. They can take the sick leave once they've accrued enough. That the good part is you're not front loading, you're not giving it away. They can only use what they've earned. The bad news is you have to track it, and that's going to be your issue there. Question, I get to this. Do you have to pay them for their unused sick time at termination? No, you do not. Not at all. The rule in the statute and the guidance is clear. You as an employer do not have to pay it out when they leave. Now, some of you will. You can have a policy that says, I will pay out your sick leave at 50% of its value. I will pay out sick leave at the full amount. I will pay out sick leave at minimum wage. I will pay out sick leave, but only if you gave me notice and you work your notice period. I won't pay out sick leave in the event you rip me off. You can come up with a payout rule. It can be whatever the devil you want it to be. Just let that sink in. That's another business decision you're going to have to make. But generally speaking, no, you don't have to pay this out. Another question that's come up. We are under 100 employees, so we provide 40 hours of paid sick time. Similar to a prior question, the employee will accrue more than 40 hours a year, but we can max the accrual at 40 as long as we put this in our policy. Yeah, so there's nothing special about the 56 hours that I mentioned. The same rule applies, Dustin, no matter which of the 4 buckets you fall into in that regard. We have employees that are commission-based only, so they have no normal rate. So can we pay sick leave at minimum wage? Lisa, that is correct. It will be the applicable minimum wage which would apply. Dustin had a follow-up question. How about rollover? Can we max the rollover to 40? Yes, you can. You only are required to roll over what the paid sick leave law says you have to give the employee in that in that regard. All great questions and what have you. Front loading, again, I've already explained the front loading rule in that regard. You give them the total amount. There's no exception. There's no quarterly front loading. It's front loading all right out of the box. However, bad thing of a front load, once you give it, you can't take it away. They gave us a lot of guidance on part-time front loading. Can I front load for part-time? And I assumed it was going to be a pro rata thing, and that's pretty much what it is. You would front load what you anticipate the employee to work, hours the employee will work, using the formula of 1 hour of sick leave for every 30 hours worked. A few things can happen. The employee can use less or works less time. Can I take away any time? You cannot. The employee works more but remains a part-time employee. You have to track their hours and grant more leave using the accrual method in that regard. The employee switches to full-time, same issue. So if you front load fewer than 40 hours, assuming that's you're in the 40-hour category, the employer must still track the employee's hours worked and accrual of sick leave, because the part-time worker may work more hours than anticipated. So there's some more slides here on the front loading of part-time, but I have explained it generally speaking in that regard. And I do have a question. Let me grab that. We don't have to keep track of accruals over and above 56 max hours correct into the next year. Yeah, assuming you have 100 or more employees, and that's why you're using the 56 hours, that is correct. Let's say you roll over 56 hours in that regard. So let me make sure I understand the question, Karen. You front load 56 hours in 2021. The employee uses no sick time. In 2022, you front load another 56 hours. You now have 112 hours that you are tracking in that regard. So if it's a question of rollover, it's what you're rolling over plus what you're front loading for the next year or accruing. If it's a question of we're going to cut off the employee at 56 hours of accrual in a calendar year, can I do that? The answer is yes. And then you would be responsible for rolling over whatever the employee did not use in that regard, and it would be added to a new accrual amount or a new front load amount. I hope that makes sense. If not, obviously you can tell me, and I will try to explain it again. Okay. Hold on, let me just make sure I went over that. All right. The accrual method. The state mandates that the minimum accrual method, you can have a higher one if you wish, that an employee works 1 hour for it gets 1 hour of sick leave for every 30 hours worked. The accrual method, you have to grab the accruals effective September 30th, 2020, or if the employee is hired after that, whatever the date is that they are hired. If the employee is out on sick leave, is that work time such that I have to count it towards the accruals? No, it is not. They've given us the answer. What about other non-working times, such as vacation time, holiday time? I give a bonus. I am paying the person subject to call-in time, but they're not working. Do those count towards the accruals? No, they do not. However, training hours, travel time must all be included in that regard. The Fair Labor Standards Act goes into detail on when travel time is compensable. Those are the rules that you will look at. That is a presentation in and of itself. As the employer, if you remember, I said in the written policy, you have to tell the employee what the minimum increment is that you're going to hold them to. The maximum minimum increment is 4 hours. You can't force someone to take more than 4 hours of sick leave. You can track sick time, though, all the way down to 0.1 increments if you want. So you as the employer set the increment use maxed out at 4, but you can go lower in that regard. Yeah, I was waiting for this question. Mike, if we front load, accruals and carryover are immaterial. Yeah, and you're going to see that because then but the other part of that is you put a cap on what you're going to be allowed to do. If you don't put a cap on, they are not immaterial. If you have 100 or more employees, you can cap sick leave at 56 hours of use in a year. If you have other than that, you can cap it at 40 hours in a year. Let's say I have a cap of 56 hours. In 2021, the employee is given 56 hours front loaded. He uses none. We roll the 56 hours over. We give him another 56 hours. He has 112 hours. We have a cap that says you can only use 56. What's the purpose of the rollover? You will see there's a slide here, and it's coming up at some point, that says the state acknowledges that there will be bank balances in excess of what the employee used. So there is no purpose unless you're paying out a termination, which is optional in that regard. And some employers are not going to put the cap on. So remember, if you don't have a cap, they are not immaterial in that regard. Can an employee use sick leave for only half of a workday? Yes. You set the minimum increment, but you can't force them to take more than 4 hours if they don't want to. Okay, employee use of sick and safe leave. We have 2 buckets of sick leave, 1 bucket of safe leave in that regard. Remember, the use rules do not start until 1/1/2021, and I do not recommend highly, please listen, don't let them use it before January 1 because it creates another a potential set of problems for you. Sick leave use is not just for the employee now, it's for the employee or the employee's family member. The law defines a family member, a parent, and a child. I'll go through those definitions with you at the end of all these buckets. The first two buckets are sick leave use. They overlap each other, as you're going to see. Sick leave can be used for the mental or physical illness, injury, health condition of the employee or the employee's family member, regardless of whether the illness, injury, or health condition has been diagnosed or requires medical care at the time that such employee requests the leave. I stubbed my toe in the shower. My shampoo, you know, those big ones, fell on my toe and it's throbbing. I'm icing it. I can't walk, but I haven't gone to the doctors. That's a legitimate use of sick leave in that regard. Bucket two, the diagnosis, care, or treatment of the same thing, mental or physical illness, injury, or health condition of, the need for medical diagnosis or preventative care of one for the employee or the employee's family member. The third bucket of sick and safe leave use is the safe leave. This is an absence from work for the employee or the employee's family member where they have been a victim of domestic violence as defined in the human rights law, a family offense, a sexual offense, stalking, or human trafficking in that regard. There are sub-buckets A through G. The reasons to use safe leave include to obtain services from a domestic violence shelter, a rape crisis center, or other service program, to participate in safety planning, temporarily or permanently relocating or taking other actions necessary to increase the safety of the employee or the employee's family member. Let that one sink in. I got to go take a self-defense class. I hired an instructor to shoot me, to teach me how to shoot a pistol. I think those are going to count in that regard. To meet with an attorney or social services provider to get information or advice on, to prepare or participate in a criminal or civil proceeding. All these sub-buckets must relate to domestic violence, stalking, sexual offenses, etc. If your employee wants to go see their attorney because they got in a car accident 5 years ago and are about to go to trial, that does not count for sick leave use. To file a complaint with law enforcement, to meet with the DA's office, to enroll a child in a new school. Or the catch-all, very broad. There's going to be a lot. I could drive a dump truck through this. To take any actions necessary to ensure the health or safety of the employee or the employee's family member, or to protect those who associate or work with the employee. Again, the sub-buckets must relate to domestic violence, family offense, sexual offense, stalking, or human trafficking. There's another exception within the law. Let's say your employee assaults their spouse. They call you up and say, I got to take my spouse to the doctor. She hurt herself. You grant sick leave. You later discover, because it's on the news, that your employee was arrested for the assault on his wife. Can I undesignate the leave as a safe leave use because the employee was the perpetrator? Yes, I can. The perpetrator, if they are the employee, are not allowed to use safe leave in that regard. Definition of a family member, parent, and child. I'm not going to spend a lot of time on it. Read it, very broad in scope, includes the concept of in loco parentis. For those of you that are not familiar with in loco parentis, let me just give you an example. I live with mom and dad. Mom and dad are drunks. The person that lives next door to me is the one that raised me, is the one that take care of me, is the one that fed me, is the one that put clothes on my back because my parents are drunks or drug addicts, whatever. I'm just giving you an example. That next door neighbor will count as the parent for in local parentes in that regard. So just keep that concept in mind. Don't automatically reject a request for a safe leave. You really have to do the in local parentes analysis. I think I mentioned this earlier. Does the employee have to file a police report? Does the perpetrator of the domestic violence have to be convicted? No. The use of safe leave is not contingent on either. Can I use sick leave? Hey, I just want to go get my teeth cleaned at the dentist. I have a routine physical. Yeah, you can in that regard. Minimum use that you can compel is going to be 4 hours. You can allow them to use less if you want. Can I use sick leave for bereavement leave? No, I cannot, but sick leave may come out of bereavement. So your employee loses their spouse, they take the bereavement leave, they are so distraught they have to go on some medication, they're not capable of working. Yeah, it might roll into a sick leave, so just beware of that. What about a facility closure because of a public health emergency? It really is contingent on the facts of the case. The DOL will take a long, hard look at it in that regard. Question popped up. Can I designate a class of employees as front-loading and one as accrual? Yes, you can. Great question, Lisa. So some employers are putting their salaried exempt employees as front-load and their non-exempts as an accrual. I just want you to define it within your policy so it's crystal clear. So another example that I've seen is anyone hired before September 30th, 2020, we're using front load. Anyone hired on or after September 30th, 2020, we're using the accrual. I think that's totally allowed as long as you are crystal clear in your policy in that regard. Great question, Lisa. Some commentators were writing articles that the COVID-19 New York State sick leave and the paid sick leave would run concurrently. That is wrong. They do not. They are independent of each other. That has now been crystallized in the guidance. I thought those commentators were wrong, but you know, who knows? Rate of pay. What do I pay the employee who's using sick or safe leave? The general rule is they will receive compensation at the regular rate of pay or the applicable minimum wage, whichever is greater for the use of paid sick leave. Wage theft prevention notice comes into play here. I'm going to ask you some questions and I need to see the notice and hopefully you use the right one. I still can't believe I'm running into Wage Theft Prevention Act form problems, but we are. How do employees who are paid on a commission, a flat rate basis, or some other non-hourly rate basis accrue sick leave? This includes your exempts. Employers who are paid on a non-hourly basis. Accrual of sick leave is measured by the actual length of time spent performing work. You got to track their hours. When are they working? That is the only way to do it. A salaried exempt, not unusual for a salaried exempt employee to work 50 to 60 hours in a week, 40 the next, 60 the next, 55 the next. And if you're using the accrual method, you need to know how many hours so you know what to give them. If you're using front loading, not so much an issue in that regard. If an employee uses leave during hours that would have been overtime if worked, does the employer have to pay the overtime rate? So we're dealing with a salaried, a hourly non-exempt employee. Let's say that the person's typical work schedule is that they have 50 hours of work hours every week, and it's scheduled. When they go to take their sick time, it's during one of the 10 hours that they're typically working overtime. Do I pay the employee time and a half, or do I pay them the regular hourly rate? You pay them the regular hourly rate. Tipped employees, do I have to pay lost tips and gratuities in that regard? No, I do not have to do that. Can an employer, on the Wage Theft Prevention Act notice, there are allowances that you may be able to take against the hourly rate. Can I take those allowances when I pay an employee for paid sick leave, or is it the hourly rate listed there before the allowance? It is the hourly rate listed before you take the allowance. What if I have multiple hourly rates that an employee used during the 40 hours in the work week? I have a training rate, a travel rate, and the regular rate, all of which is allowed. You use the weighted average just like you would when you figure out if they worked over 40 hours, what the regular rate would be. The formulas here for you to take a look at. Again, can't consider allowances or credits that you can claim. Nothing in the law requires you to pay out sick leave, as I've indicated that. I've also indicated to you, you can come up with a payout rule if you want to, but there's nothing that requires you to, so you can be as creative as you want. If you are unionized, check your CBA for payout rules. Even if you're not unionized, do you have, do I want to revise any of my payout rules in that regard? So it's not just about adding a sick leave policy to your handbook. We have to consider ramifications elsewhere in the handbook in that regard. Okay, the seasonal employee, and this will come up, it come up in lots of businesses. Well, typically it's coming up in the construction industry. Hey, you know, Mike, we really only work 9 months a year. I'd lay everyone off for the 3 hard months of winter, December, January, February. We bring them back in March. Does their accrual bank continue through the layoff period? It does if there is an anticipated ongoing employment relationship. They've clarified that it doesn't start over again. Mike, Johnny worked for us for 2 years. He quit. 6 months has elapsed. And we rehire him. Does the accrual, we use the accrual method, does he start over or does he get what he had? It starts over. The employment relationship ended in that case. Notice and related issues. I told you earlier, the state of New York has not told us what we can and cannot ask for by way of documentation for an employee's sick leave. This is all they've told us. This is in the statute in that regard. So it's two-prong rule. An employer may not require the disclosure of confidential information relating to the medical condition of the employee or the employee's family member. I interpret that it might be the actual diagnoses. It might be what the doctor or healthcare provider said to the employee, because that's a confidential communication. I don't think it's get me a note that you took your mom to the doctor. Johnny was here, he took his mom to the doctor. I think that's okay, is my reaction to it. There will be no documentation. I dropped that big thing of shampoo on my toe in the shower. I can't walk. I did not go to the doctor's, but I take 3 days of sick leave. I don't think there's anything you can do about it in that regard. The second limitation is you may not require the disclosure of information relating to absence from work due to domestic violence, a sexual offense, stalking, or human trafficking as a condition of providing sick leave. I think what that means is you can't get into the nitty gritty. What happened to you? You know, get into the gory details. No, I don't think that's what they want you to do. If I had to go meet with a DA, maybe the DA gives me a note, Jane met with me. If I had to go file a police report, maybe I get a note from law enforcement. Maybe I give them a redacted copy of the police report showing the date and time that I went there. I think there are things we're going to be able to ask. This will be the subject of the regulations, and we'll see what the state says. We're going to have to play it by ear as of right now. Can a employer require an employee before using sick leave to find a replacement worker? No, that's silly. Of course you can't. How much notice does the employee have to give? I've already answered this. A second. That's it. Now, I think we need to recognize before we go through this slide, there's two types of leave here: foreseeable and unforeseeable. I know 6 months in advance when my next dentist appointment is. I think that's normal. I know when my yearly physical is going to be. I make an appointment to go to the doctor's. He's getting me in 3 days. That is foreseeable. I think what you ask for in your policy is, if you know you or your family member has a doctor's appointment, please let us know as soon as possible. The other part of the rule is unforeseen. I think they can give you 1 second notice, and there's nothing you're going to be able to do about it. Okay, question. When people work for us, we give them 2 weeks of vacation sick time and make it clear that it's all one and the same. I'm assuming this won't work. Sorry if you answer. Okay. No, it will work. And we're going to explain that in a little bit. There are rules you have to comply with. So I call those a paid time off policy, where you have a bank of time together. You can do that. And we're going to get to that in a minute in that regard. So that's the notice provision, not very helpful to us as employees or as employers. Oh, no, I thought it was another question. They just said thank you, so you're welcome. All right, so what if my title changes, my status changes, I transfer and promoted, demoted? Does my accruals move with me? Absolutely, they do. If the employment relationship does not end, no matter what happens, your accruals come with you. What if there's a change of ownership or merger? I think it's typically going to depend on the deal itself. We're hiring everyone. Everyone is seamlessly being integrated. I think your accruals will come. If everyone is fired, but we're only going to hire 10 of you, I think the accruals don't come in that regard. So it'll be a fact-intensive analysis on the change of ownership in that regard. It'll be a case-by-case basis. Okay, carryover rules. Now, the carryover rule I've already indicated. Any unused sick leave must be carried over into the next calendar year. It doesn't matter if you use accrual or front load. Mike, can I pay it out as opposed to rolling it over? No, you can't. It's not allowed. You are allowed as an employer to put caps on leave. If you have less than 100 employees, I can cap it at the max that I have to let you accrue up to, 40 hours. And if you have over, I can cap it at 56. Whether you have a cap or not is a business decision you need to make, and you need to put that in your policy. When, for purposes of funding, not figuring out what bucket I go into, do I have to use the calendar year, or can I use a fiscal year, or the employee's anniversary date? You can use some other 12-month period, as long as you consistently apply that across the board to everyone. Again, payout cannot occur. Carryover must occur. It is the only option, anything unused. And again, here is the state's acknowledgement. If I have a cap, and in 2021, the employee was accrued 40 hours, didn't use any, I roll it over. In 2022, they start the year with 40 and they start accruing again. They don't use, they accrue 40 more. and they don't use it, we roll over the 80. It's going to result in a leave balance in the bank that is in excess of the amount that they can use. The state simply acknowledges it. That is all I can tell you. It's silly. That's an acknowledgement. I bet you they do something else in the future on this, but we'll see. The carryover has a direct benefit on the accruals, just so you know. If I'm an accrual employer, the employee earns 40 hours, uses 30. The benefit is they roll over 10, and on 1/1 of the second year, they have 10 hours of sick leave immediately available to them. Non-discrimination rules. What is a good employment law without the ability of them to sue you? No employer can discharge, threaten, penalize, or in any manner discriminate or retaliate against an employee for exercising their rights under the law. This includes requesting sick leave consistent with the law or using sick leave consistent with the law. Penalties are under what has been under Section 215 of the labor law. They can file a civil lawsuit or file an administrative complaint with the New York State Department of Labor Anti-Retaliation Unit. Fines of up to $20,000 are possible. The employer may have to pay loss compensation. There's this open-ended payment of damages to the employee. That can mean lots of things. Liquidated damages, which would result in like a doubling of the award, and you might have to reinstate the employee. So I put, and also criminal prosecution is a possibility when you're messing with someone's wages. Can I discipline someone who's abusing sick leave? Yeah, but make sure you're right. So let me give you this scenario. Johnny calls in sick. He goes to the doctor, gets a prescription. You just know he called in sick. TV station is at the mall that day recording, and you're watching the news at night, and all of a sudden you see Johnny walk in the background, and your reaction is, that son of a gun, he called in sick and he was at the mall. Abuse. I don't know. Talk to him. Johnny, why were you at the mall? I dropped my script off that my doctor gave me at the CVS pharmacy in the mall. They told me it would be 1 hour before it was ready. I walked down to the food court to get something to eat. Here is my receipt for my prescription showing what time I picked it up. Legitimate use of sick leave, not abuse. Or it could have been the opposite. That's why you always ask. You're always allowed to inquire as to illegitimate use of sick leave. I would tell you have a basis for doing so. I think it makes your life a lot easier in that regard. Okay, so another question I have. If in 2022 an employee has 80 hours accrued and rolled over, we are only required to allow them to use 40 hours, even though that they already have 80. That's correct. You can limit the use and put the cap on it if you wish. You don't have to put a cap on it. That's a business decision you're going to have to make here in that regard. The guidance established that the owners have individual liability for failing to provide sick leave. So, you know, make sure you realize if you're an owner on this call and you don't comply with this law, you have individual liability in addition to the business. They've indicated how a complaint can be filed over the phone, by email, and they made it nice and easy for the employees. Existing employer policies. Very simple rule. All of those of you that have PTO. Now, remember my position. Pull out the sick leave, have a standalone policy. You don't have to listen to me. You can keep it all as one bucket if you wish. Here's the rule. The employer is not required to provide any additional sick leave if the employer has adopted a sick leave policy or time off policy, paid time off policy. PTO policy that provides employees with an amount of leave which meets or exceeds the requirements of the law. Don't stop there. However, you must also satisfy the accrual rules, the carryover rules, and the use requirements. If you fail on any one of those, your PTO plan does not count, and an employee can come after you for sick leave. So you can do it. But the other thing, we're getting questions like this. Let's say we give the employee 80 hours. They use 80 hours, but it was all for vacation. There's 3 months left in the year and now they get sick. I don't think you got to give them any additional time. They used it all. They chose to use it for vacation. We didn't care what they used it for. That was up to them. I think you're fine in that regard. Can I continue to have a leave donation policy where employees who don't use their leave can donate it to others who need it? Yes, you can, as long as it is voluntary. Impact of collective bargaining agreements. We only know what the statute says, that you can, any collective bargaining agreement entered into on or after September 30th, 2020, you can be as creative as you want to be. You can provide for leave in the form of compensation or other employee benefits or some combination thereof, and you can negotiate terms different than the Paid Sick Leave Act. However, your CBA must specifically acknowledge the provision of this law. That's why I gave you the citation to it early in the matter. And the DOL recommends some language here about the benefits being provided are comparable benefits for the employee, and you specifically label and identify that. Okay, simple enough, Mike, but you said that's only for employees, an employer within a new collective bargaining agreement. What about existing ones? I think you have to reach out to the union, open up negotiations, because it's clear to me you have to provide paid sick leave on or before January 1. And when I say on or before, if you're using an accrual method in your CBA, you have to start the accruals on September 30th. If they refuse to open up negotiations, you may have to file a complaint with the National Labor Relations Board against them, or in that regard. Some collective bargaining agreements have provisions that address what if there is a superseding change in the law that requires something. It could also be as simple as, yeah, the union says, yeah, why don't we open it up? We'll, most CBAs probably have greater benefits, and probably all you need to do is a memorandum of understanding saying this benefit is designated the New York State Paid Sick Leaves, specifically reference 196B of the labor law. I think that's going to work for you. Does this impact bereavement? No, as I've indicated, bereavement leave does not qualify as paid sick leave, but as I also indicated, sickness could roll out of bereavement, in which case paid sick leave is going to be triggered in that regard. There's a job restoration rule. Sickness is now, sick leave is protected leave, just like FEMLA and paid family leave. There's a job restoration rule. You must restore the employee to their same position, same title, same working conditions. There's an employee use rule. An employee is allowed to ask their employer, how much have they accrued? How much have they used? What do they have left in this calendar year or in a prior calendar year? And you must respond. You must respond within 3 business days. Some employers are choosing to put this on the pay stub. That's fine. You still have to respond in that regard. Impact of other laws. The COVID-19 sick leave is independent of the paid sick leave law. The Paid Family Leave Act, an employee can choose to use paid sick leave to fill in the gaps if the employer allows it. So the difference between what the insurance carrier is paying and what their regular rate is. They wanted to make sure that the employee can never receive more than their full wages if they're getting paid family leave and paid sick leave in that regard. Other federal and state leave, the New York State paid sick leave law is independent from those. You still have to be on the lookout for local laws. We have 2 of them here in New York, which we're concerned about. The Westchester County law survives in that regard, and the City of New York law also survives. And if you have employees in either, you'll have to comply with both laws. The City of New York amended their Paid Sick Leave Act effective September 30th. If you'd like a copy of the amendments, feel free to email me and I'll email them to you in PDF format. But it makes it interacts nicer with the state law. I'm not covering the city law on this webinar or the Westchester County law. Lastly, record retention, and then I'll open it back up for questions. The law adds 1 record retention requirement to Article 6 of the labor law. The employer must establish, maintain, and preserve for 6 years contemporaneous, true, and accurate records for each work week, showing the amount of sick leave provided to each employee in that regard. So with that, I'm going to open it up for questions. I do have one here already. Can the accrual begin on 1/1/2021, or do we have to start on 9/30? You have to start on 9/30. There's no option. It's right in the statute. Counting employee question. What if your physical employee count for a calendar year exceeds 99 due to turnover, but your actual positions are under 100? Would you be considered over 100? Catherine, that is the question that is begged by the lack of an answer from the state of New York. I would tell you to calculate it until we see the regulations using the higher number, because I'm not sure. And so if we're not sure, we'll always go higher. They have not issued any guidance. That will be the subject of their regulations, which are about 6 months off. Will you be sending the slides out to us? My understanding is the slides were sent out to everyone. If you did not receive it, check your email. And if you didn't get it, just call the chamber. They will email it to you. Those are all the questions I have. Here we go. Okay, good. So keep the questions coming. I'm happy to answer. What happens when an employee starts on 1/1/2021? We front load our PTO on that date. What happens to those who are hired after that? Lisa, I think you front load a pro rata amount. So if they're hired on January 5, I'd front load the whole amount. If they're hired on December 31, I front load nothing in that regard. I think you just sort of figure out what do you anticipate their hours to be for the year, using the 1 hour of sick leave earned for every 30 hours worked. What's that number? And that's what you front load. I think it's the same thing like if you're front loading a part-timer. Take a look at those slides in that regard. Mike, do we have to track exempt sick time? You sure do in that regard, or at least their hours worked for their accruing it. What if I give my salaried exempt employees unlimited sick time? I think that sort of takes care of the issue, and there's no problem in that regard, but you still need a policy in that regard. I'd want to think through a little bit the carryover on that. I'm not quite sure what would happen, but I can tell you there's no answer. We'd have to just think it through. Other questions, folks? Okay, if a common owner has several separate LLCs, do we count it as one business in your employee count? Christina, this is an integrated employer question. I do believe that the Department of Labor would follow the integrated employer test in this regard. If they are truly separate LLCs and there's no interplay between them. So like some of these LLCs share CFOs, share HR, share resources, operate out of the same building. That's an integrated employer, and I would total all of them up. But if I own 5 different businesses, they're not integrated in any way. I think each business will stand on its own. Christina, this will also be the subject of the regulations that they are publishing. That's the best I can tell you right now. The 2, what I call the bookends, the closer calls will be more difficult. Can we apply front loading by class of employee and use an accrual for another? I did answer that. Yes, you can. There's no problem. You need to make sure your policy is crystal clear that that is what you are doing in that regard. Other questions? Mike, when I asked about the combined vacation sick policy, you seemed to indicate you were going to talk about it. Is the answer is simply okay, then no need to further discuss? No, that was the slide I put up about, here, I'll put it back up right now. The existing employer, that's this slide right here. The employer shall not be required to provide additional sick leave if the employer has a sick leave policy or a time off policy. The time off policy is the combined policy that you're referring to. But remember, you have to meet or exceed the requirements of the law and comply with the accrual rules, carryover rules, and use requirement. If you do all of those, you're golden in that regard. Perfect. Yeah. Yes. Good. Anything else, anyone? And again, if you think 5 minutes after we get off this, you think of something, shoot me a quick email. If you have to type 6 pages, I'm not going to answer it. But if you give me a quick paragraph, I will answer it. We are assisting employers with their policies, helping with some of these business decisions in that regard as well. I see no other questions. I want to thank you all for inviting me. We will be doing this again when the regs come out. We might do it again when the proposed regs come out. But make sure once you finalize your sick leave policy, make sure it interacts nicely with the rest of the handbook. The question I got, tell us what the question is basically what I do. I do labor and employment only. I represent employers only. We help in every aspect of labor and employment work, from development of policies to day-to-day counseling to litigation, everything in between. I do tons of training. I probably trained, I think the number count is, I think I've done 65 training sessions so far this year, almost all of them over Zoom in that regard. So really, if you have a question on labor and employment, we can help no matter what the question is. Okay.
Michael, did you see the questions in the general chat as well?
Oh, no, I didn't, but thank you. Where is that?
So I think if you just change it.
Well, that's what I've been answering, everything that was in the chat.
Okay.
I don't see where there is another, sometimes there's a question bar along the bottom. I don't see that on mine.
Okay.
So
I think they're all in the chat. I just wasn't sure if they were showing up all in the same place or if you had to switch over to see the ones sent to everyone compared to the ones sent privately.
Oh yeah, I think some were sent to me privately.
Okay.
So some did, some of you did not see all the questions, but I've answered every question that came up, be it so that everyone saw it or privately. I don't think I missed anything.
Okay, thank you.
In that regard. Okay, well, good luck. More to come in this regard, and I wish they had given us all the rules, but typical state of New York. comply on January 1. We'll give you all the rules by April. Great. Thank you all. Have a great holiday. If I don't talk to you again, I think we do have another one scheduled for November, and I'll probably do one more. But thank you all, and take care and have a great day.
Thank you, Michael, and thank you everyone for joining us today.